his ex-wife's lawyer hand-delivered a certified letter to the front desk of a building that bore his name on the deed. The woman, who had walked out of their marriage 14 months earlier, who had told the mediator he was going nowhere, that she was cutting her losses on a man with no ceiling, was now demanding 40% of the company she had never believed in. 40% of a business valued as of the previous fiscal quarter at $212 million. She had signed the divorce papers herself. She had used her own pen. She had smiled doing it. Her lawyer's name was Trenton Ware, and he was the kind of attorney who wore cufflinks to depositions and spoke in a voice calibrated to intimidate men who didn't know they were allowed to sit still and wait. He had filed a motion claiming fraudulent concealment of marital assets, that Marcus had deliberately hidden the company's trajectory during the divorce proceedings. Ter did not know what Nicole had never once thought to ask in 9 years of marriage was that Marcus had not hidden anything. He had simply built something after she left. He had built it deliberately and methodically, the way he had always built things, the way his father had taught him, with worn hands and a level that never lied. What happened next would cost Nicole Delaney Ellen everything she thought the law had promised her. Before we jump in, you need to hear. The morning light came through the glass wall of the corner office in long, clean angles, and Marcus sat with his coffee going cold beside him the way it always did when he had too much to think about. He wasn't looking at the city below. He was looking at the framed photograph on the credenza, not of Nicole, not anymore, but of the first set of architectural drawings he had ever completed without a supervisor checking his work. His father had framed them. He had been 22 years old. His father's voice came to him sometimes in the early mornings, in the particular quiet before the phone started and the building filled. Measure twice, Raymond Allen used to say, bent over the kitchen table with his reading glasses low on his nose. Cut once, and don't ever let a man rush you through the measuring. He had been a master carpenter for 40 years, and he had never once built anything that failed under weight. Marcus had taken that lesson and turned it into a career in structural engineering, then into a consultancy, then into a development firm that specialized in adaptive reuse, taking derelict industrial buildings in secondary cities and converting them into mixed-use residential anchors. The work required patience that most competitors lacked. It required the willingness to sit on a distressed asset for 2, sometimes 3 years before the conditions were right. It required, in other words, exactly the temperament that Nicole had spent 9 years reading as limitation. She had not been wrong about what she saw. She had only been wrong about what it meant. He had met her at a fundraiser for a youth architecture program 11 years ago now. She had been standing near the blueprints displayed on the far wall, actually looking at them, which made her unusual in a room full of people who attended such things for the cocktails. She had asked him a question about load-bearing walls that showed she had done genuine research before coming, and he had spent 45 minutes explaining cantilever design while the rest of the room mingled around them. She had worn a blue dress the color of architectural tracing paper and laughed with her whole face. He had called her 3 days later. She had answered on the second ring. For the first 4 years, the marriage had been good. She was a brand strategist, sharp and social in ways that balanced his tendency toward silence. She filled rooms, he emptied. She translated his work to investors who needed narrative as much as numbers. They had been, for a time, genuinely complementary. But somewhere in the 5th year, as the business ground through its first real contraction and the money tightened and the timelines stretched, she had begun to look at him the way people look at a vehicle that hasn't started in 3 mornings, like a problem that wasn't worth the diagnostic. She started attending events without him. She stopped asking about the projects. She acquired, over the course of 2 or 3 years, a vocabulary of quiet dismissal. Eventually, she would say about his plans, or maybe someday, or the one that had lodged in him like a splinter, "I need more certainty than you can give me." He had been working through the early stages of what would become his largest acquisition when the separation papers arrived, a former textile mill in Greensboro, 300,000 square feet, priced low because the remediation timeline scared everyone else off. He had run the numbers 60 times. He knew what it would be worth in 36 months. If the municipal incentives came through the way the city planner had indicated, he had not mentioned it during the divorce proceedings because it wasn't yet an asset. It was a liability with a future. He had disclosed everything he was required to disclose. He had measured twice. It was his paralegal, a young woman named Destiny, who had been with the firm 2 years and had an almost supernatural gift for pattern recognition, who first noticed the irregularity. She had flagged it on a Thursday in the middle of a deposition prep session, setting a printout on the edge of his desk without interrupting the way she had learned to do when something needed his attention but not immediately. He had picked it up after the client left. It was a motion filing. Trenton Ware, attorney at law, on behalf of Nicole Adrian Delaney, Ellen, Nee Delaney. Petition for post-decree asset discovery and equitable relief. 40% of the Meridian Properties Group, LLC, estimated current valuation, $212 million. Marcus read it once. He set it down, he picked up his coffee, found it cold, and set it down again. His hands did not shake. His face remained perfectly calm. He picked up the filing and read it a second time more slowly, the way he read structural assessments, looking not for the conclusion, but for the load-bearing assumptions underneath it. The motion rested on three claims. First, that Nicole had been a material contributor to the business during their marriage through her brand consulting work. Second, that Marcus had deliberately obscured the Greensboro acquisition during proceedings to prevent it from being classified as a marital asset. Third, that the appreciation of the business was a direct continuation of work performed during the marriage and therefore subject to equitable distribution under North Carolina statute. He opened his laptop, he created a new folder on the desktop and named it simply Where. Then he began to pull records. It took him 4 days working in the early mornings before the office filled. He built a timeline that covered 9 years of business records, cross-referencing Nicole's documented contributions, 3 brand decks, 1 naming exercise, 1 client dinner series that had produced 0 conversions against the actual trajectory of Meridian's revenue. Her work had been real. It had also been, in the revenue record, effectively 0. The company had grown despite the branding, not because of it. The Greensboro acquisition had been initiated 14 days after the separation papers were filed. He had the time-stamped emails. He had the preliminary term sheet. He had the date-stamped voicemail from the city planner that predated even his first conversation with Nicole about the separation. He had not hidden the asset. The asset had not yet existed as an asset. More importantly, and this was what settled something cold and clear in his chest, the divorce decree was final. The settlement had been negotiated, signed, witnessed, and filed. Nicole had walked away with the agreed sum, $240,000, the Lake Norman property, and her retirement account intact. She had not been defrauded. She had been wrong about it, but she had hired Trenton Ware, who worked on contingency for exactly these kinds of cases, and Trenton Ware had apparently convinced her that being wrong was actionable. By Friday morning, Marcus had built a complete counter-document file. He had drafted a summary of the timeline for his attorney. He picked up his phone and made a single call. "Claudette," he said, "I think I'm going to need a full morning." There was a brief pause. "How full?" "Bring the junior partner." Claudette Osei Mensah had been a domestic and corporate litigation attorney for 28 years, and she had the kind of stillness in a meeting room that made opposing counsel nervous without her having to say a word. She was 61, lean with reading glasses she wore on a chain, and a habit of marking documents with a silver pen she had carried since law school. She had represented Marcus on the original divorce proceedings, and she had represented his firm on 4 acquisition closings. She did not rattle. She reviewed the Ware filing for 12 minutes while Marcus sat across from her and her junior partner, a methodical young man named Graham, who took notes in a system Marcus didn't recognize but clearly worked, given how fast he could retrieve things. When she finished, she set the filing down and removed her glasses. "He's fishing," she said. "He's hoping you'll settle to avoid discovery litigation. The fraudulent concealment claim has no factual basis if your timeline holds, and your timeline will hold because you are structurally an extremely well-documented person." The Greensboro acquisition, initiated after separation, closed after divorce, appreciated after divorce. It was not a marital asset. It was not a concealed asset. It was a future asset that became a present asset after she voluntarily exited the marriage. She picked up her pen. What I want to know is the provenance of her contribution claims, the brand work. Marcus slid a folder across the table. 3 documented engagements, total invoiced value to the firm, $42,000 over 4 years. She was paid as a contractor. We have the 1099S. We have the deliverables. We have the revenue records for the periods in which her work was active. Claudette looked at Graham. Graham was already writing. We're going to file a motion to dismiss on the fraudulent concealment claim and a counterclaim for abuse of process, she said. Ware knows this filing won't survive discovery. He's betting you're afraid of the headline, $200 million divorce battle. She looked at Marcus steadily. Are you afraid of the headline? No, Marcus said. He said it simply the way he said most things. And she nodded once. Good. Then we proceed. She paused. You understand this is going to cost her considerably more than she recovers, if she recovers anything. I understand. She'll have legal fees. She'll have discovery costs. Ware will likely withdraw if we counter hard enough, which will leave her exposed. Claudette looked at him over her glasses. This is not cruelty. This is the shape of the law when applied to a claim without merit. Marcus nodded. My father used to say there are 2 ways to use a tool, for its intended purpose and for everything else. He picked up his copy of the folder. She's using the law as leverage. I intend to use it for its intended purpose. Claudette almost smiled. The second conversation happened the following Saturday morning at a house in Concord where his uncle Bertrand had lived for 31 years. Bertrand Ellen was 67 and retired from a long career as a site foreman, and he kept the kind of yard that told you everything about his character, not manicured, but deliberate, every plant placed with a reason in mind. He had been the person Marcus called when his father died, and when the first big deal fell through, and when Nicole told him she wanted out. He was not a man who offered comfort as a reflex. He offered clarity. They sat on the back porch with their coffee, and Marcus explained the filing. Bertrand listened the way he had always listened, without moving, watching the middle distance. When Marcus finished, Bertrand was quiet for a moment. Then he said, She left because she thought you were small, yes, and now she wants a piece of what she left because it turned out you weren't. That's the argument. Bertrand shook his head slowly, not in anger, but in the way of a man who has seen a particular pattern so many times it no longer surprises him. I knew her, Marcus. Not well, but I watched her. She was always measuring, always calculating what things were worth to her right now. She never had the patience to ask what things might be worth later. He set down his mug. Your father didn't build things that were valuable immediately. He built things that held up. Big difference. Ware's argument is that the business value is a continuation of the marriage. Bertrand looked at him. Is it? No. The project that made it what it is was initiated after she filed. Then the law will say what the law says. He picked his mug back up. Don't give her $1. She is not owed. Not one. There was something in the directness of it that settled Marcus the way only Bertrand's directness could. Not encouragement, something cleaner than encouragement. Permission to proceed without guilt. He drove back to Charlotte that afternoon and spent 4 hours with Graham going through Nicole's attorney's evidentiary basis. What they found, as they traced the sourcing of Ware's valuation arguments, was that he had relied on a forensic accountant who had worked exclusively from public records and the financial disclosures from the original divorce filing. He had not deposed a single Meridian employee. He had not requested internal project timelines. He had not, apparently, reviewed the LLC operating agreement, which contained a provision standard in Marcus's template, included in every entity he formed, that specified the company's assets were the separate property of the managing member in the event of legal challenge. Nicole had signed that operating agreement as a witness. She had been present at the notarization. She signed the thing that defeats her own claim, Graham said, not quite believing it. Marcus looked at the document for a long moment. She was there for the signing because she thought we were building something together, he said. She didn't read it carefully because at the time she wasn't planning to take it from me. He said this without bitterness, which was the only way he knew how to say it. File the exhibits package when Claudette is ready, he said. All of it. In the evenings that week, he went home and ate dinner and answered emails and let the work proceed at its own pace. He had told no one in his personal circle about the filing. There was nothing to tell yet. He had measured. He was cutting once. The mediation was held on a Wednesday morning in a conference room on the 14th floor of an office building in uptown Charlotte because Ware had requested it as an alternative to a full motion hearing. Claudette had agreed, not because Marcus needed it, but because she wanted Nicole and her attorney in a room with the full weight of the documentation visible on a table before anyone said a word. Marcus arrived first. He had requested that he and Claudette and Graham arrange the document sets in the order they had planned. 10 manila folders and 2 bound exhibit packets, placed precisely, nothing theatrical about the arrangement. It was a table of evidence, not a performance. He poured himself a glass of water and sat with his hands loose on the table and waited. Nicole came in with Ware at 9:13. She wore the kind of professional confidence that people wear when they have convinced themselves the outcome is already decided. She was still composed, still polished, and when she saw Marcus, she gave him the particular expression he had last seen in the mediator's office 14 months ago, a look of faint condescension that had once bothered him and now simply registered as data. She had not noticed the folders yet. Then she did. Ware set his briefcase down and opened it with the crisp snap of a man who expected to control the room. He had barely arranged his papers before Claudette spoke. Mr. Ware, before we begin procedural discussion, I'd like to direct your attention to Exhibit Packet A, which contains the signed LLC operating agreement for Meridian Properties Group. The 1099 records for all contractor payments made to Nicole Adrian Delaney Ellen during the relevant period, the time-stamped correspondence file for the Greensboro acquisition from initiation through closing, and a chronological financial record demonstrating zero material contribution from Miss Delaney Ellen to the company's primary revenue-generating activity during the marriage. Ware did not open the folder immediately. He looked across the table at Marcus. Mr. Ellen, I think there's a productive conversation to be had here about Exhibit Packet B, Claudette continued, as if he hadn't spoken, contains the operating agreement signature page with Miss Delaney Ellen's witness attestation, the notary stamp, and the date. I'll let you locate that page at your convenience. The room was quiet. Nicole looked at Ware. Ware opened the folder. It took him less than 90 seconds to find the signature page. The shift in his posture was subtle, but Marcus had been reading structural load for 17 years, and he could identify the moment weight redistributed. There is a path forward here, Ware said, recovering, modulating his tone downward toward negotiation. My client contributed meaningfully to this business as a strategic partner, and the spirit of the equitable. She was paid $42,000 as a contractor, Claudette said. We have the invoices. We have the 1099S. We have the performance records. Her contribution is documented, quantified, and fully compensated. She paused. The fraudulent concealment claim fails because there was nothing to conceal. The asset didn't exist during the marriage. The operating agreement defeats the marital property argument. And the signature page defeats the argument that she was unaware of the company's legal structure. Nicole spoke for the first time. Her voice was controlled, but just barely. Marcus, she said, with the particular intimacy of a person invoking a first name as a tool, you know that I was part of everything you built. You know the work I put in. Marcus looked at her. He kept his hands where they were. He spoke quietly. You put in work, Nicole. You were paid for it. You decided to leave, and the settlement reflected the honest value of the marriage as it existed on the day you filed. He paused, not for effect, but because he wanted the next part to be accurate. What happened after you left is mine. Not because I hid it from you, because I built it after you were gone. He looked at her steadily. You told the mediator I had no ceiling. You were right. I don't. The room held that for a moment. Nicole looked at her attorney. Ware was already doing the calculus. visible to anyone who had ever watched a man recalculate his contingency fee against his exposure. Mr. Ware, Claudette said, we will be filing a motion to dismiss the fraudulent concealment claim this Friday, along with a counterclaim for abusive process. You have 2 business days to withdraw the petition voluntarily. After Friday, that option is no longer available. She closed her folder. We're done here. Marcus stood. He gathered the copy of the exhibit packet he had brought for himself, though he wouldn't need it now. He buttoned his jacket. He looked once more at Nicole, not in anger and not in triumph, with the particular kind of clarity that comes from finally being on the right side of a long calculation. I'm not angry, he said. I'm clear those are different things. He walked out, the door closed softly behind him. He did not look back. 11 months later, the tomatoes in the raised bed off the back deck had split at the seams with their own weight, and Marcus stood in the early morning with a coffee that had not yet gone cold and watched the light come sideways through the oaks he had planted the spring after the divorce. The new house was in a neighborhood he had bought into 2 years before anyone else recognized what it was becoming, which is simply the way he bought everything. He had spent 4 months renovating it himself, not because he couldn't pay someone, but because some things needed to be done with your own hands to mean what they were supposed to mean. He had laid the floors in the main room, board by board. He had built the deck himself using his father's level, which he still kept in the toolbox in the garage. Renee had been the one to suggest the raised bed. She was a structural auditor he had met during a municipal inspection process on the Greensboro project, a quiet, exacting woman who asked questions that revealed the architecture of a problem before she stated her position on it. They had taken 3 months to become friends before either of them acknowledged it was becoming something else. She was there on Sunday mornings. She was not performing anything. Meridian had closed the Greensboro project at a final yield of $58 million. He had used a portion of the profits to launch a mentorship program for young Black architects and engineers in Charlotte, Memphis, and Philadelphia, a foundation he had named quietly and without announcement after his father. Trenton Ware had withdrawn the petition 8 days after the mediation. Nicole had been left with Ware's fees and the discovery costs she had already incurred, a total, Marcus had heard through Claudette, of something near $90,000. Her social consultancy had lost 2 anchor clients in the months following the filing. Once word had circulated in the professional community about the nature of the claim and its collapse. She was working, as of the last information that had reached him, for a mid-tier firm in Raleigh. Her mother had not spoken to her since learning the details of what she had attempted. Marcus had heard all of this through Claudette. He had moved on. He heard the screen door open behind him, and Renee came out with her own coffee and stood beside him without filling the quiet with anything unnecessary, which was one of the things he had come to understand about her. She knew what silence was for. The light was coming up fully now over the oak canopy, and the garden he had planted from seed was doing what gardens did when you prepared the soil correctly and gave things the time they needed. Some things, he thought, were worth the patience to build right. He was free, he was solvent, he was unbothered. I hope you enjoyed that one. Next story. I've picked out 2 more for you that I think